And welcome back to another edition of The Road to Financial Independence. I'm the president of CPS Investment Advisors, Mike Riskin. And as always, I'm joined by my partner and CEO of CPS, Peter Galacco. Hey, Pete.
We got a great topic.
We do. It's a continuing of our estate planning series that we've been doing.
And I'm sure they've been watching a bunch of them.
That's right.
It's going to be an important one. It really is. I think it's going to be information that everybody needs to know.
That's right. And we've been talking about the different types of terminology, different processes of estate planning, the documents. We've spent a lot of time on the documents. And today, we're really going to dive into
the boogeyman.
The boogeyman, that's right. And I know on the probate process.
The probate process
and best practices. And I think on some of the previous podcasts, we've sort of mentioned the probate process is maybe not a great thing.
No, I'm not a fan.
That's right. That's something to avoid. But luckily, it is an important thing to be aware of. And
there are times we need to use it.
And who better to help us walk through that process than our very own Derek Oxford. Derek, welcome to the show.
Oh, thanks for having me. Appreciate it. It's an honor.
Awesome. Well, Derek is one of our senior advisors here at CPS Investment Advisors. Been with us a very, very long time. He's a certified financial planner as well as an accredited estate planner, an AEP. Did I get that right?
That's right. You got
okay.
it right.
I was nervous about that credential, getting the name right, but
he's not an attorney.
But
he does the planning, not the documents.
He does the planning, and he has spoken at a lot of conferences and whatnot on this topic. So, yes. Derek, thanks for joining us again. And so kind of just diving right into it. One of the myths out there that I hear from time to time is that, and certainly something that Pete and I have expressed on our other shows, is that probate's, it's complex, it's costly, it's the worst thing that could ever happen to you.
Right.
Myth or fact?
Total myth. Total
myth. I don't know. Pete's going to argue about it.
Yeah, well, we'll see. We'll see.
I'm sure Derek has a good argument here.
It is a good argument, but honestly, it is a myth. It's not a good thing, but I wouldn't say it's necessarily a bad thing either, especially for clients.
Okay. Explain a little bit into why maybe it's not a horrible thing or bad thing.
Absolutely. There are times where people who are dealing with an estate don't have anyone to turn to, and the probate process is very clear-cut, and the courts will help you through the process and figure out who's going to get what and how.
Okay. And what one of the complaints that Pete and I always seem to have is sort of the time frame and the costs. Kind of maybe go into that a little bit.
Right.
That certainly might be a negative, but maybe it's not. Maybe it's I don't know if it's a positive, but
it can be, and I think that all depends on who you work with.
Mm-hmm.
There are certain attorneys who are going to charge exactly what the Florida statutes tell them to, which is a flat 3%.
Of the gross estate.
Of the gross
not what's
estate.
Probate, but the gross estate.
Exactly.
Okay. So that sounds like that could be pretty costly if you're not careful.
Could be a big number.
Yeah.
In some states, it's as high as 8%.
Yep. And
wow.
One of the issues I always have is it's the family that has to write that check. And we're always asked as planners, was there a way we could have avoided that?
Mm-hmm.
And, doing a revocable trust would have avoided putting transfers on death. But for those that don't do that or don't do any planning, this is the avenue you're going to have to go through.
That's right.
Yeah.
That's right. There is no choice. You must go through it. In the state of Florida, there is a 90-day creditor period that must happen to ensure that anyone that, that the estate owes money to gets paid. And that process could be anywhere from 6 to 12 months.
Yeah. The 6 to 12 months to figure out,
including that 90-day period, 6 to 12 months. That's standard
to settle the. So what 6 to 12 months. So, and we talk about the gross estate. So
right.
what would end up being in, could my house end up being in
it absolutely will.
In probate,
yes.
if it wasn't titled properly?
So anything that's not anything that's registered in your personal name.
Okay.
The only way to get that out of your personal name is have a judge sign off that it can be moved to somebody else, and who that is. And that's probate. It's getting assets transferred outside of the person, the deceased name.
But this is after you die.
After you die.
Right.
And you just can't, if it's in Michael Riskin's name and you pass away, nobody can change that name other than a judge.
Okay.
Or if you have estate planning that the document says this is what happens if it's left out.
So even if it's in my will, it still would need to go through the probate process.
That's correct.
Yes, it will.
Because the judge has to determine, read the will, so to speak, and determine all that.
And I think there's also a big misconception when spouse passes away and there's a surviving spouse, that everything automatically goes to the surviving
Oh
spouse.
yeah, I hear that a lot too.
No, the state says no.
Yeah.
Now, at the end of the day, yes, that's probably
If you
what's
don't
going
have
to
a
happen.
will, then only half goes to the spouse, the other half goes to the children. If
It
there's
depends on
children.
the state.
Correct.
Yeah, in Florida. Yeah.
Right.
So, passing away intestate without a will, it could be dangerous for the family. And your wishes are not going to be 100% taken care of.
That's right.
Well-
With a house, let's just say that that's a family house. People have lived in it for a long time. There's a lot of memories that go along with that property.
Yeah.
It could need to be sold in order to settle the estate.
That's correct.
Well, so it's really, from what I'm understanding from this conversation and previous discussions, there's kind of three scenarios: either titling things properly, so to speak, before you die to avoid probate. You can die with the assets in your name, but it's spelled out in your will how it's supposed to go. And then there's, like Pete said, in dying intestate, where it's in my name, but I left absolutely no direction
That's correct.
as to. So those are kind of the three general scenarios.
Right.
That you're
If you,
dealing
if you die without a will, if you die with a will, then the courts are going to read that will.
Right.
And the probate part of it is going to be changing the names into the new names of the beneficiaries. So that's what you're paying for. So you can die intestate without a will, same thing, but the court's going to decide who gets what.
But the court decides.
Correct.
Exactly,
The
not you.
safest way to avoid that would be to do some estate planning where you can transfer assets outside of probate. So, that's really, my first go with a client is, let's see if we can avoid probate. And, really the biggest complaints are from the heirs. They got to wait 6 to 12 months. It's usually more like 12 months because everybody's busy.
Right.
Right.
And it costs a lot of money. It really does. Not only do you have to pay for the probate, you got to pay the executor who's actually helping. So there's even more money going out. And sometimes it doesn't sit well with the family when they're expecting that this should be transferred the day after death.
Right. I think
So-
managing the family expectations is probably key here.
Correct. And
Very
waiting
much.
a year creates a lot of hostility. That's what I've seen.
Yeah.
But there are reasons that we need it. I mean, I've seen it where, if you file probate, the creditors, the statute of limitations starts to
Oh, that's
to
true.
hit. I believe it's 2 years.
It is 2 years.
But if you don't go to probate, there is no statute of limitations. So if you have debt and you want to make sure that debt doesn't come back to bite you, then maybe go through probate, pay the fee and do that.
Yeah.
But I think it's a cost benefit analysis at that point.
That's
you
right.
know.
What an idea. What a novel idea that you pay a little bit of money now so that not only is your estate safe or safer, but then your heirs don't have to worry about this entire hassle.
Yep.
Right.
And believe it or not, it is a hassle.
Right.
Because whoever the executor is, either if it's not a will, the court's going to pick one, or if it's in the will picks it. That's a lot of work because you got a lot of moving parts. You got to deal with attorneys. You got to deal with court. It's a lot of work.
Yeah. Especially when we think about who tends to be designated as the executor. We're usually not talking about paid professionals, right?
No, we're talking about children of the
Family members.
family
right.
member,
Usually
brothers
family
and
members.
sisters, maybe some that don't even live in the same state.
Right.
So there's a lot of things to think about. That's why estate planning is critical when you are trying to figure out who gets what and how they're going to get it.
Mhm.
But
Right.
that's why, I think probate is needed, but there's ways to avoid it.
Right. Exactly. And one of the things we were discussing earlier is really it's not. So my understanding is that probate is really the laws can be different between the states, right?
They can be.
It's
They
not
can
a
be.
federal thing. It's more of a state by state issue.
No, and a lot of times we're dealing with the state of Florida just because that's where we live and reside. and
Yep,
work.
a lot of our clients are. Yep.
That's right. But there are other clients that come from other states. Maybe they had state documents from that state and never got them changed over, which is a huge problem. But states are making it easier to go through the probate process, especially over the last few years. It's really been summarized for any amount of money that is left outside of any kind of will substitute beneficiary to be able to pull that back in.
Okay.
In Florida, if you pass with just your house in your name and that's the only asset you need to transfer, that's only a couple months.
Right.
That's an easy probatable asset. So, let's say that you have your trust done, but somehow you didn't put your house in. It's not going to be as catastrophic as it would be if you had stocks and bonds in your name or other assets that need to be transferred.
Right.
That's right. Most of the time, as you mentioned, it's a house, it's a vehicle, it's a small bank account.
That's right. It's real estate. I think would be that's something I think we run into a lot. They have the house in New York or North Carolina, but they die in Florida, and that's where they lived. Yeah.
And you brought up a good point, Mike. People that have houses or assets in different states, you got to make sure that you're taking that consideration, because that may be probate. There's different rules in every state.
Yeah, that's exactly.
And if the asset is sitting in a state that has different rules, you're going to have to abide by those rules.
Yes.
So a lot of people say, well, I want a house on the beach up in the Hamptons and one down in Florida. Well, you got to make sure you understand how all those moving parts work.
Yeah. And maybe do some of the advanced planning ahead of time so that you can, even if you don't avoid probate in your own state, at least what can you do to avoid probate in the other states?
Yep.
It would be beneficial to meet a professional in that state for whatever asset you have to ensure that everything is locked up together.
Yeah. And one of the other things I see here on the presentation you did was one of the key areas, probate records are public. So I think that's really an interesting point, especially when you talk about creditors, but also, if you have trusts or you have next generation or you have other business partners out there, if your assets pass through probate, that's public record, right? I mean, that public record, anyone can.
That's right.
Wow.
You pay a small fee, you go to the Circuit Court of Florida, and you can access that information.
So if Pete dies and all his stuff goes through probate, I can go in there and find out everything
So I'm going to go on the edge here and say that not many people want that to happen.
I think so.
So, that's another thing you need to consider. Do you want your whole financial life, good or bad, to be out there for everybody to see?
Right. That's a great point. Well, as we all know, and most of our audience knows, we are a bunch of CPA financial planners here at CPS, and so maybe discuss, Derek, a little bit for us what a unique role CPAs can play. I know most people associate attorneys with the estate planning process, and obviously they're the key piece in the documentation and working with the clients on that. But what someone like CPAs, CFPs, financial planners, what are unique roles in estate planning?
I think it's a fantastic item to bring up, and one that a lot of people do overlook, because we can go in there and help with the tax strategy piece of an estate and how that's supposed to work with rolling it out to beneficiaries. Maybe you have a trust that gets created, and we can work with attorneys to help that process. There are so many timelines when it comes to probate or an estate. I mean, for example, you have to file a tax return for an estate in a certain amount of time. Right. What if you didn't know what was happening? As you mentioned, Pete, there's a 2-year process with creditors. Well, again, if that hasn't been done, there are ways to correct that. Well, who's going to know how to correct that? Your professionals that you're working with.
Yeah, correct.
Yep. And also there's other, even on the pre-death side, in the planning phase, I know a lot of times we'll work with our, we have great relationships with attorneys. They do wonderful work. But a lot of times they do charge by the hour. And so sometimes a lot of the planning, if you're working with the right team, the right estate planning attorney, the right CPA, the right financial planner, a lot of that planning can be done up front.
Yep.
And then go to the attorney with a game plan. Now, of course, you want the feedback from the attorney and the valuable insight they'll provide. But really, we can do a lot of the upfront
and that's
discussion, right?
That's very important. A lot of people will not go and get their estate plan done because they got to sit in front of a professional, an attorney who's smart, who's going to talk lingo that they really don't know how to answer. And they're afraid they're going to be asked a question that is going to stump them, and they may never get it done.
Right.
So coming to a financial planner and sitting down and going through all of your options, this is what they're going to ask you, and here's what you can do. Right. When you're picking a trustee, this is what you need to think about. When you're picking a person that's going to take care of your kids, these are the things you need to think about. And you go to the attorney with the answers already done.
Right.
And maybe modify a little bit with their recommendations, but it saves them money in the long run, and it gets them exactly what they want without a lot of stress.
Right.
And usually we go to the attorney with them to help with that stress.
Yes.
To make sure that we're all talking the same lingo.
And I can tell you, every time that we go with the client to an attorney's office, the attorney is happy.
Right. No, that's why I wanted to preface it by this wasn't a dig on attorneys, because they're incredibly, obviously, the integral part of the process, but having other professionals and people you work with can add value, and the attorneys appreciate it typically because they want the back and forth, who's going to be trustee, who's going to take care of the kids, the back and forth. If you have to go in there 4 or 5 times, most people don't want to, like attorneys don't want to have, they want the documents, the planning.
Yep.
If our clients have those discussions with us ahead of time and we can really help guide them through that, we can go to the attorney's office a lot cleaner, things get done a lot more efficiently.
Yeah, we can get over, a simple estate plan in half an hour, where it may take an hour and a half for the attorney to ask all the questions and educate the client. And that, that's saving the attorney time that they can get more work done.
That's right.
That's right. And even after the fact, after the estate plan is done and complete, and maybe we get a copy of it with the client's approval, we can go through that document with the client every few years just to make sure there's anything that needs to be changed. Maybe there was a life event that happened, and that's an opportunity, again, to have that discussion before you go to the attorney's office to make the change.
No, that's a great point. The ongoing monitoring. I know in general, how often, I guess maybe it does depend on your age. How often should you be reviewing these documents?
Every 5 years.
Every 5 years?
No matter what, no age.
No matter what. You just have to be cognizant of big changes that you need. You have another child and you only have 2 children, and you may need to add something to it. But usually 5 years will give enough time where we can look through and say, any changes? Not really, and we move forward. Usually it's later on in life that they're going to have more change, when the kids are out of the house and maybe grandkids, they want to do a little bit more planning.
Right.
And that's when we really look at it and do stuff every 5 years.
Yeah. Plus our clients are aging with us. And so a lot of situations where the person that they had as the trustee or the executor, well, now they're 20 years, they might be when they were 55 or 60 was fine. Yep. Now they're 75 or 80. So they might even pass away before you do. So really changing those, knowing who they are, did they move out of state, and those considerations, right?
Those are great points. And address changes, phone number changes, co-trustees, successor trustees, things like that are all important.
And if you're listening to this and you're planning on moving out of state, the state that you're in, to another state, understand that when you do that, you got to update all of your estate planning. It's all done by state. All states have their different rules and regulations. So if you live in Florida, you got to have your planning here in Florida. If you live in Michigan, you got to have it in Michigan. If you live in New York, you have it. So make sure that you're aware of that.
Yeah.
People forget.
That's it. It's funny. Louisiana has a very unique plan when it comes to the estate, and it actually ties back to French law from when it was owned by
that
France.
makes sense. Yeah.
And still to this day, there are little bits and pieces that you have to follow. It seems just trivial to us, but it does happen. So it is by state. Absolutely.
Yeah.
Nice. Well, it's never, I think the next point of conversation that we can get into a little bit that you can never get sick of, and certainly one of Pete's favorite is what are some primary probate avoidance techniques? And I know we've discussed it on prior podcasts, but like I said, I feel like this is really an area that we focus on in terms of in the sense of setting our clients up to avoid having their families have to deal with unnecessary stress after they pass. Right. And I hear Pete say that all the time.
Transfer of wealth to the next generation. Yeah. And if we can do that, that's a preferable thing. If we can't do that, then there's other things, other hoops we have to jump through. So
Derek, what are some of the few, major things that you can do? Even right now, somebody listening to this, they could go out tomorrow and get with their financial institution. So what are some recommendations we make about trying to avoid probate?
It's so easy, Mike.
All right. I like to hear that.
Putting a beneficiary.
I like easy.
Yes, absolutely.
I got the easy button.
Putting a beneficiary on anything that you can will help avoid the probate process. I don't care if you have a will that states what's going on. If you have a beneficiary on any type of account, that supersedes what's in your will.
That's correct.
If you can put a person on death on a bank account, a transfer on death on an investment account, beneficiaries on your life insurance policies, beneficiaries on your 401ks, any retirement accounts, all of that will help avoid probate. And then, of course, as we mentioned with a real estate transaction, having a life estate deed to immediately go to an heir or multiple heirs.
Mm-hmm. So that's a type of beneficiary designation.
Yeah, like a ladybird deed.
Yeah. Okay.
Yeah. In the state of Florida, we use the term ladybird deed after Lady Bird Johnson. But it is a life estate deed where that property can pass outside of probate to your heirs. Okay.
Now, this may be a silly question, but I've done those beneficiary designations, and life happens, and God forbid one day, you get divorced, and I have my spouse. Am I allowed to change these beneficiary designations, or am I stuck once I make them?
A lot of them you can change at any time. Now, 401ks have very specific rules if you change your beneficiary to someone other than your spouse.
Okay.
There's some additional signatures and notarization that needs to happen, but for the most part, yes, you can change them as much as you want to.
Okay. No, that's good to know because I know I can only imagine that conversation if you got divorced and you passed away and you got married for a second time and your first wife was the beneficiary of your account.
That's not good. You got to keep a look at your beneficiaries and any professional that you're using. Make sure they're looking at your beneficiaries also.
Yeah.
One area in the beneficiaries that I always find that's incomplete is the contingent beneficiary.
Oh yeah, okay.
And
explain that a little bit.
So,
what does that mean?
So there's two beneficiaries you can put on any account. So we learned life insurance and IRAs and 401ks always have beneficiaries on it, but you can put them on other assets. But when you do that, you can put a primary beneficiary. You can give it to anybody you want. All right. So the primary beneficiary is going to be who gets the money when you pass.
Okay.
Whoever that is, you can do 100% to one person, 10% to a number of people. If something happens to that primary beneficiary and you don't have a contingent beneficiary, guess what? You're going to probate.
Oh, and it's back in your state.
It's going right back in your state because there is no beneficiary.
Right.
So I always recommend make sure there's contingent beneficiaries.
Okay.
It's a great rule.
And if you need help with that, going through that process, ask somebody to help you with it because that's so important.
Perfect.
There are opportunities in the estate that you can fix that, especially in a will. If you have minor children, you can have a testamentary trust set up. There are opportunities if there's no specific person to name as that contingent.
Mm-hmm.
A trust after death is a great option.
Yep, it definitely is.
Oh, nice.
It definitely is. Yeah, so, you don't put you can name your last will and testament as a beneficiary, and if there's a trust set up in that last will and testament to get the accounts, it'll go into that trust.
Oh, that's great. Yeah, we've talked a lot about trust, and I think the trust strategy is another one of those techniques to avoid probate, right?
Yep.
That's right.
Yeah. Okay. And what about if I'm married? So we discussed marriage, husband and wife. Is it better to have my accounts set up with a lot of spouses say, well, it's just I had in my account before I got married and I had this account before she got married.
Yes.
And let's just keep them the same because that's how should they at least put each other's name on their accounts, or should they keep them separate, or how does that look like?
Well, it all depends on who you want to get the account. If you leave
the marriage is good,
the judge is going to pick who he wants. So if you want to make sure that,
assuming they're in a good marriage,
yes.
If you want to make sure that your spouse inherits this money, you can do it in two different ways. You can put a beneficiary designation on it, a transfer on death, or you can put a joint account. You can do it jointly. Since you're married, there is no gift tax that goes along with it. And in the event that you pass, there's nothing anybody has to do. It's already in their name. So having the joint account's good. If you do a transfer on death, there's something you have to do. You have to transfer the money to the spouse. So those are a couple ways you can avoid having those issues.
Okay.
Right. And there's something unique about Florida, as well as maybe half or a little bit half than the states, that allows married individuals that have a joint account to have special creditor protection. Called a TBE, or tenants by the entirety. Mm-hmm. So in the state of Florida, again, they are allowed to have a tenants by entirety account, which really does protect that account as a joint account, just for married individuals.
Even an added benefit there in terms of asset protection.
If you're a Florida resident and you're married and you've got an account with your spouse, make sure it doesn't say joint tenants of the rights of survivorship.
Okay.
It has to say joint tenants in the entirety. And I would make sure your account actually says that. Yeah. It's very important for liability purposes. Right. Very important.
Nice. All right. And so just as a final wrap up, we sort of hinted at this earlier in the program. There are obviously going to be times when probate is unavoidable, or necessary, or when you would want it. We mentioned the debt thing. So just before we wrap up, just talk about when probate might be necessary, or unavoidable.
That's right. Again, it's not bad, it's not good, but it can be necessary, and it does provide that final guidance to the family and to the heirs who are already grieving over the loss of someone. They want to be able to move forward with it, and the state is very straightforward with the rules and regulations around probate and how to take care of the estate for them. Okay.
So are there any specific scenarios that might come up where we definitely need to go through probate or want to go through probate?
You don't have any heirs.
Okay.
That's
and
one.
You don't know where the money, where you want to put the money.
Yeah.
That way the courts will decide who gets the money.
Okay.
The better way of doing that is if you're philanthropic, give it to a charity.
And I've actually run into that scenario. I have several clients who are single, maybe never got married, don't have kids, and have no idea who's gonna, like, it's actually a stress of theirs.
Yes.
They've been losing sleep over it on what's going to happen to their fortune, or their wealth, I should say. Yeah.
A lot of individuals think that they don't have enough to have an estate plan done. And
Oh yeah, I hear that a lot too.
yes, and that is when probate is going to happen. So I would say that by default, typically an estate of 75,000 or less is probably going to go through probate because they never had their estate plan done. And if that's the case, and hopefully that number gets smaller and smaller, then you'll see that probate process happen. And again, there are individuals to help you through it.
Correct.
Nice. Yeah. Well, Derek, I appreciate the insight and the guidance. It was a great conversation. I think
I still don't like probate.
That's right.
But I feel a little bit better about it.
If Pete had one of those change my mind, I hate probate, change my mind. I'm not sure we accomplished that today.
I don't know.
But we can always have you on the show.
We know why. We know it's necessary.
But we know the reasons why. Yeah, exactly. And we know it can be a necessary thing that we have to go through in our lives.
That's right.
It's good to understand all the bells, buttons, and whistles and what you're up against, because a lot of times people don't understand what probate is.
Yeah.
And we do executor work and trustee work a lot of times, and they look at us like we're doing something by keeping their money away, when in reality we can't distribute it.
That's right. Yeah, it's very frustrating for the family.
Yes, absolutely.
Yeah.
They don't quite understand it.
That's right.
So just a little bit of education always goes a long way.
100%.
Important.
Yeah, and that's certainly what we try to provide with you on this on this podcast, and hopefully we did that again today. So thanks for joining us today, and we'll look forward to seeing you on the next one.
All right.
And if you like this content, please don't forget to subscribe to us on our YouTube channel. And as always, you can reach us at www.cpsinvest.com, or feel free to give us a call at the number on your screen. We'd absolutely love to hear from you.